Successfully responding to defense requests for interrogatories. An important part of answering interrogatories or Roggs is to minimize potentially harmful testimony for our client. Make sure the client that is answering carefully answers each question and limits their response to only the question being asked. Timing is key. It is your responsibility to educate yourself about your client and ensure they understand the deadlines at play. Make sure you understand. Roggs are due within 30 days of receipt. Missing the deadline will lead to CR26I conference. CR26I conference will disqualify that attorney and paralegal/lit assistant from bonuses for the quarter. Motion to compel for CR26I issues can result in sanctions to the law firm. Make sure the client understands. Every person in litigation has to answer these questions, including our opponent. How quickly they can gather their responses makes them look like a better candidate for early resolution of their case to the insurance companies. Bad clients are bad witnesses at a trial, good clients are good witnesses at trial, and therefore the insurance company won't want to go to trial. Mark the deadline on the calendar. Remember, they are due 30 days from the date of receipt, but it is always advisable to turn these in early. When answering Roggs, you should only object if there is a reason. Instruct your witness to tell the truth at all times. Advise the client they should attempt to answer these on their own, then schedule an appointment in office or over Zoom to complete them in 7-10 days. Most clients will not begin these on their own. Some clients are better at paperwork than others. Schedule the in-office discovery meeting and place it on the calendar. The attorney does not need to do this meeting. It is the responsibility of the lit assistant to provide the attorney with a complete draft of responses for them to review and then approve for submission to the opposing counsel. Requests for production or RFPs are frequently included with Roggs. Opposing counsel will ask for answers to a question and then ask for an RFP of any document associated with the answer to that question, such as photos of the accident, medical bills, or records. Impress upon our client how crucial it is that they understand how long it usually takes to gather these records. Some of them are in our control already if the client did treatment while we represented them. Other documents they will be responsible for gathering and meeting the deadline. If you tell them they are due in 30 days, they will frequently be late. Tell the client they need to gather the documents in 7 days and provide them to you at the in-office discovery meeting. Everybody understand that RFPs take forever. Avoid impeachment. Additionally, you'll want our client to understand the concept of impeachment. The opposing counsel will do what she or he can to impeach the witness or attack the client's credibility. If the client gives testimony at trial that is different from the testimony given during the deposition or through written discovery like Roggs and RFPs, the opposing counsel will use this against them. Again, it's important to underscore the importance of providing truthful and consistent testimony. It is sometimes appropriate to object to the question when answering Roggs. Plaintiff objects to this interrogatory as vague, ambiguous, argumentative, overbroad, unduly burdensome, and not reasonably calculated to lead to the discovery of admissible evidence. This is a classic general objection you should use sparingly. Boilerplate objections do not go over well with judges. Plaintiff objects to this interrogatory because it calls for the plaintiff to make a legal conclusion. Don't go crazy with this one either. An interrogatory is not objectionable merely because it asks for an opinion or contention that relates to fact or the application of law to fact, but the court may order that the interrogatory need not be answered until designated discovery is complete, or until a pretrial conference or some other time. Fed. R. Civ. P. 33A2. Plaintiff objects because this interrogatory calls for pure conjecture and speculation. It is not the plaintiff's job to guess what would have happened in an alternative universe. Plaintiff objects to this interrogatory because this interrogatory is so broad, uncertain, and unintelligible that the plaintiff cannot determine the nature of the information sought. Therefore, the plaintiff cannot provide an answer. Plain. Tiff objects to this interrogatory because the only possible purpose of this request is to harass and cause hardship to the plaintiff and needlessly increase the cost of litigation to the plaintiff or her counsel. Plaintiff objects to this interrogatory because it seeks information from third parties and information not within its possession, custody, control, or personal knowledge. Plaintiff objects because this request calls for the disclosure of attorney work product prepared in anticipation of litigation or for trial. Moreover, the defendant has failed to demonstrate a substantial need and the substantial equivalent of which the defendant would be unable to obtain by other means without due hardship. Thank you for watching this training and being a crucial part of our law firm team. If you have feedback about how to make this video better, please reach out.